Alison Thewliss to move the motion. Before your contribution, Ms Thewliss, I think it's become obvious to everybody that there may be quite a strict limit on speeches. Alison Thewliss.
Thank you very much, Ms McDonough. I beg to move that the House have considered paragraph 3225 of the immigration rules. To assist those who wish to intervene or speak later on, I'm going to speak a bit about the background, recent case studies from my constituency, and then I have some questions for the Minister, if that helps you kind of tailor your remarks. I first want to begin by paying tribute to the members of the Highly Skilled Migrants Campaign Group, who have now held 4 large demonstrations outside this Parliament. They've also been extremely active in social media. They have self-organised and worked hard to give this issue the attention it deserves. And I'd also like to thank Amelia Hill at The Guardian and Kirstine Patterson at The National, who have provided first-rate coverage to this issue. To give some background, the Home Office has been, for at least over a year now, issuing highly skilled migrants, many of whom who entered the UK under the Tier 1 general route, with notices detailing that their leave to remain application has been refused. Many of these decisions, Ms McDonough, it seems, have been predicated purely on applicants' alleged poor character in the wake of amendments to their tax returns and income statements. And in making these decisions, the Home Office has deemed highly skilled migrants as a threat to national security under paragraph 3225 of the immigration rules. And Ms McDonough, that section reads, the undesirability of permitting the person concerned to remain in the United Kingdom in light of his conduct, including convictions which do not fall within paragraph 3221C, character or associations, or the fact that he represents a threat to national security. Ms McDonough, this is highly inappropriate. It's important to note that section 3225 is discretionary. It should be for the Home Office to determine whether or not to use it based on the merits of each individual application. And it also places the burden of proof on applicants rather than on the Home Office. And what I have seen from my constituency casework and from listening to the stories of highly skilled migrants outside and those who have contacted me, is that this is regimented, calculated decision-making. Individuals are being refused wherever they have supplied details of different incomes or sought to amend information in a tax return, often on the instruction of an accountant. None of those whom I've spoken to have any issues which would cause them to be considered a threat to national security. And indeed, the very invoking of this clause and recording of it could compromise that person's future work and travel. What country, after all, would wish to accept somebody refused from the UK on such grounds? When applications are refused, it's incumbent on the applicant to challenge the decision through the courts. Many examples exist where the judge has overruled the decision of the Home Office, finding it entirely disproportionate. A number of individuals' refusals appear to be predicated on nothing more than the individual making an honest mistake. And as far as HMRC are concerned, when the correction has been made, the case is closed. Some of the sums involved in these corrections are only a few pounds, £1.20 and £1.60 in some cases have been reported. Some of the sums involved were many years ago, one of my own constituents from 2010. And many people have asked me the question, if there was a problem back then, why didn't it affect my status at that point? I raised this matter with the Financial Secretary to the Treasury at questions in May, and he confirmed that people should clearly continue to make appropriate changes to their tax returns, and further, that Treasury Ministers and HMRC officials are working closely across government, particularly within the Home Office, on the issues that I raised in order to ensure that we get these matters right. Of course. Yep.
First of all, congratulate the Honourable Lady on bringing this forward to Westminster Hall for consideration. Does Honourable Lady not agree that some of those who have been affected are doctors, highly skilled people, highly valued members of our medical society, for example, in the Ulster Hospital in Northern Ireland, and indeed in hospitals throughout the United Kingdom, Great Britain and Northern Ireland? We must ensure that those who are actually living and working and pouring into and making a difference in their communities, as they are able to continue without undue stress of overly onerous immigration procedures due to simple, non-criminal mistakes on tax returns that perhaps maybe some in this House have even made themselves.
The Honourable Member is absolutely correct. And many of these people that I've spoken to are people that are in shortage occupations and are very much valued, the very people that we would wish to attract to this country to come and work. Of course.
And just like her, several highly skilled migrants in my Slough constituency have had Home Office applications refused due to the heavy-handed application of paragraph 3225. Of those contacting me, many have lived in the UK for over a decade and have British-born children and are now in an absolute state of despair. Ms McDonough, one told me, I have given my best years and contribute to the growth of Britain. My private family and professional life are established here. I am a law-abiding citizen and have never faced criminal charges of any kind. Does my honourable friend agree with me that it's very difficult to respond to somebody in such circumstances, and indeed that this hostile environment of this Tory government needs to end?
I absolutely agree with my honourable friend, and it chimes with many of the stories that I have heard too, and particularly the impact on children, because they don't know why all of a sudden their parents aren't allowed to work, and some of them have not been able to access medical care for their children as well, which is deeply worrying. Of course.
I'm sure she will be aware of a case of my constituent who was an individual who had this rule applied to him, but actually in many ways the biggest impact was on his wife, who NH Scotland removed access to any medical services for, even though she was 8 months pregnant. And whilst it is completely the case that NHS Scotland and indeed Home Office staff have very difficult jobs in very high stressful situations, when mistakes are made they can have really serious consequences which are very hard to unpick.
I thank you very much for that intervention, and I have a cause to meet him, his constituent as well, and is deeply concerned about that. I am so concerned that I have written to the Secretary of State for Health in Scotland to ensure that all GP practices in Scotland understand that they can't just book people off their lists in these circumstances, and certainly women who are 8 months pregnant need medical care and should not lose it due to the errors of the Home Office. If you give me a wee bit to make a wee bit of progress, I would appreciate it. It seems extremely odd to me that the HMRC could be satisfied, but the Home Office should treat that same behaviour as being akin to deception at the least and terrorism at the worst. If the Minister and I, as the Honourable gentleman from Strangford mentioned, or anybody else in this room, made a legitimate in-time correction to our tax return, the consequences would not be that our lives would be turned upside down, that a threat of removal would be placed over our heads. It's said that 500,000 British citizens amend their tax records every year within the 1-year grace period the HMRC allows. And others, of course, will do it outside of that time period. None of these people, Ms McDonough, will be served under 3225 or treated as criminals. The only reason that highly skilled migrants are being treated in this way is because of their nationality. And as far as I'm concerned, that is discrimination under Article 8. In one case that was reported to the press, an individual who came to the UK via the Tier 1 route went through this process. He presented a letter from his accountant detailing the error was the fault of the accountant, as well as a letter from HMRC explaining that they were satisfied that the individual was not in any way acting dishonestly, but the Home Office refused to exercise any discretion or change its original decision. In another case, an individual found that his tax information, after it had been scrutinised by 3 different appeal courts, found no evidence of irregularities whatsoever. And the individual's lawyer noted that the Home Office had made a basic accounting error in comparing the client's gross income to his net income.
Well, only way.
Of course.
I'm grateful for her giving way. She made an excellent speech. Isn't that one of the key points? The Home Office officials don't know anything about tax, and they're making decisions about people's lives on tax. This has to be taken away from them today.
I absolutely agree with his point, and it is, the QC Paul Garlick, who specialises in extradition and human rights law, said of this that the system's crippled by not having enough people to do the work, while those who are there don't understand the basics, as he very much says. They genuinely have no idea of the difference between tax years and accounting years, or what is a legitimately deductible expense. He goes on to say, my feeling is that since Theresa May's announcement of the hostile environment for immigrants, caseworkers have been told to look for discrepancies that could form the basis of an accusation that the applicant is lying, because that is the quickest way to dispose of an application. Of course.
Thank the Honourable Lady for giving way. She's making an excellent case. Is it not true that HMRC have wide-ranging powers and where they can prosecute where there's any whiff of criminality? And in none of these cases have they taken that route, because this is a mistake or it's just a genuine small error like many of us have made.
She's absolutely right. If there was a case to answer, HMRC would have something to say about it. That is beyond doubt. And the impact is also wider than the individuals involved. And I spoke last week to Salim Dadaboy, who employs 20 people in his business. And all of those people would be made unemployed in a British company worth £1.5 million wound up if this situation is not resolved. Ms McDonough, this is economic madness, and the Home Office should carefully consider the impact of their target-driven culture on the economy, especially in these uncertain times. And I've spoken to many highly skilled migrants, all of whom have been distressed at the way they've been treated, having given the best years of their lives to the UK and made their home here. We should be thanking this group, Ms McDonough, not putting them out. My constituent, Omar Kitab, travelled to the UK on a study visa in 2006, completed a Masters in International Marketing at University of the West of Scotland in 2009, and has since worked in journalism and marketing before starting up his own business. His accountant completed his tax return on his behalf, and the errors that the accountant inadvertently made were rectified by my constituents months later. Omar has written documents from his accountant proving this and accepting full responsibility for those errors. Now, Omar also suffers from depression and anxiety, a factor that his GP and psychiatrists have acknowledged that would undoubtedly contribute to his inability to spot an administrative error in his tax return. And his stress has only worsened due to the ongoing nature of his case. And he has said, "I feel this is my home. I thought my children will grow up here, that I will get married and die here. That letter saying I don't belong to this place, I'm a threat to national security, it's very hard to swallow." Ms McDonagh, it's hard for all of us to swallow.
Will the honourable member give way?
Of course.
I'm grateful to the honourable member. Does she not agree with me that as it is a sort of terrorism-associated provision, this paragraph, the implications are very wide-ranging. It leaves a black mark on these people's lives forever, and it means that it's very difficult for them to ever get a visa or work anywhere worldwide after all this.
Absolutely, and that's why there needs to be a proper, thorough inquiry into the use of this clause, because if Home Office staff are being advised to go and use this as a means of refusing people, they are quite clearly not looking at the full implications of this and the long-term impact it could have. Now, for my constituent Omar, he was refused leave to remain on the basis that he deceived the department, which goes entirely against all the evidence that he's provided. HMRC have written to him to say that they are satisfied that he's acted honestly, that he's not tried to deceive anyone. Mustafa Ali Beg also travelled to the UK to study in 2006. He obtained a master's degree in international marketing from the University of the West of Scotland in 2009. And Mustafa and Omar, they have a lovely picture of the two of them after they graduated. These two young boys with all their lives ahead of them. And Omar certainly is almost unrecognisable from that picture, from the stress that he has been under due to this. So since coming to the UK, Previous to coming to the UK, Mustafa obtained a Bachelor of Law degree at the University of Punjab. He has a Master's degree in political science, and he's worked in business development, marketing and public relations. He's undertaken voluntary positions for civil rights and social action groups. He also volunteers to run a current affairs radio show and is very much part of the Glasgow community and has gone above and beyond to advocate for his friends. As far as I'm aware, Ms McDonagh, there is no question over his integrity. But due to this rule, as the honourable member just pointed out, he's now being told that he's of questionable character, that he's a threat to national security as a result of correcting a small error on his tax return in 2010. There is no basis in which to remove somebody in this way. His case goes to the Immigration Tribunal on the 20th of July, and this proves the 20th of June, rather, and this proves that the decisions on these cases are still being made, despite what the Home Secretary has said. Mr Sanjeev Pandey travelled to the UK in 2005 on a student visa and graduated from Glasgow University in 2008. He started his own IT business and was also employed as an IT consultant and project manager, a very lucrative career, Ms McDonagh. Most recently, he was leading an IT project for a bank in Scotland before his right to work was removed by the Home Office. He had applied for ILR under long-term residency rules in 2017. He's been in the UK for 12 years at this point. He hired an accountant, but in the tax return submissions were subsequently questioned by the Home Office. Now, Mr Pandey made attempts to change his accountants as a result of this, to rectify the errors, but the Home Office have continued to pursue him on the basis that they believed him to be dishonest. Now, most distressingly, Mr Pandey was detained at Heathrow Airport following return from a family holiday in 2017, with his passport and BRP confiscated from immigration officers, removing his right to work. This has had a huge impact on the family's finances, Ms McDonagh, as he has a mortgage and other commitments. Now, judges found in his favour both the upper-tier and first-tier tribunals, and the paperwork from the first-tier tribunal states this in some detail. I'll read it out. It's a long quote, but I think it's worth putting this on the record. The judge at the first-tier tribunal said, "The refusal letter, I think, is confusing itself in relation to the appellant's income, but I have to say that I found both the appellant and his wife to be credible witnesses. I do not think that they have acted dishonestly. The appellant relied on the advice of an accountant. He was entitled to rely on that advice, and while he is under a duty to check information, it's entirely unfair to expect him to have a level of accountancy and tax knowledge accorded to professionals in this field. He was clear, he sought clarification from the accountant, but eventually, when he was unable to get satisfactory answers, he's changed his accountant. It also appears to me that the appellant was unfairly treated by the Home Office. His passport was retained during the first appeal proceedings. As a result, he was unable to find employment, since employers refused to employ him without the benefits of having his passport. He was, I think, therefore prejudiced, and I consider that this matter should be taken into account in the question of proportionality. Taking all of the above into account, therefore, I do not consider that the appellant has acted dishonestly. He may have been misguided, but that's a different matter, and I consider that it would be disproportionate in the circumstances to expect the appellant and his wife to leave the UK, particularly as they own property in the UK, they pay tax in the UK, and they've spent a considerable number of years here. Lastly, I want to highlight the case of a female constituent. I don't want to name her because her children are at school in my constituency. And she travelled to the UK from Nigeria and was refused leaves to remain in the same circumstances under 3225. She legitimately made changes to a tax return, and the Home Office is similarly putting forward an argument that she's tried to deceive the department and have refused her an administrative review. My constituent is actually a qualified accountant and has been able to continue seeking work in her field as a result of her status imposed by the Home Office. She has been made destitute as she has no recourse to public funds, as many under the Tier 1 route have no recourse to public funds. And she's been to my office to seek help in getting school uniforms for her children. Without being able to work, she's struggling to keep her family afloat, and there's a very real risk that she will be made homeless as a result of the Home Office decision with her children as well. Her landlord, the Wheatley Group, confirmed just yesterday that due to the support of her church paying her rent, they are not proceeding with legal action to evict her at this point, but that option very much remains open. I'm extremely grateful to the Wheatley Group for the discretion that they have made, but Ms McDonagh, this situation is not sustainable. My constituent needs to get back to work. This issue has all been considered by the Home Affairs Select Committee, and the Home Secretary has entered into correspondence with the Chair, committing that all 3225 applications will be put on hold and a review carried out by the end of May. Ms McDonagh, as far as I can ascertain, that review has not yet been published and no further detail is available on that review. And as I mentioned with my constituent Mustafa, decisions are being still made. I'm happy to take this intervention.
Congratulate her on this debate and apologise. I missed the first few minutes due to the business in the chamber. She's absolutely right that we're still not clear on the Home Affairs Committee on which I sit where the government is going on this matter. And would she agree with me that actually what this scandal shows is that there's a wider systemic problem in the department, as we've seen through Windrush, through this, and a series of decisions being made wrongly, that when you have hostile environment, lack of discretion, cuts in staff, cuts in ability, and ministers who quite frankly don't have a grip of what's going on in their department, the net result is damage to individuals and their families.
Yeah. I absolutely agree, and it's quite worrying that even the Home Affairs Select Committee can't get certain answers on these things, because it is of huge concern, and these decisions are clearly, from the people that I spoke to at the Highly Skilled Migrants demo last week, decisions are still being made. They are clear upon that.
I'm very grateful indeed to the Honourable Lady for giving way. She's being very generous and she's making a very, very powerful speech. Does she not agree that the Home Office was made aware of these issues in letters from myself and others around this room right back in mid-March, and no action was taken at that stage? And it's just not good enough to have this delay in action when it's affecting people's lives in such a terrible manner.
Yes, I would absolutely agree with her. And the constituents that have been to me, I've been trying to get answers for some months as well. The woman I mentioned came to see me in January, and she has still not yet got answers on her case. And it's not always evident when constituents come to us that they are affected under these particular rules as well. You often have to see a refusal letter to understand exactly why the refusal has been made. So there have been growing numbers of people getting in touch with me to say that this has been their circumstance. And all of them who have not been my own constituents, I've encouraged to get in touch with their MPs as well, and I'm sure they have done with a number of people in the room here today. Ms McDonagh, to add insult to injury, the Times reported this morning that a new visa route for migrants who want to start businesses in the UK is to be expanded to include non-graduates under efforts to increase technological innovation. Ms McDonagh, this is rank hypocrisy. How can the UK government reasonably expect to attract new migrants to the country when it treats the highly skilled population who are already here and have been for years with such utter disrespect? Ms McDonagh, I have a number of questions which I hope the Minister can assist with. When will the review that was mentioned be published? How many cases are in progress? And how many are awaiting judicial review? I had asked the Home Office how many people had been refused under this, and I understand that Channel 4 News also put in an FOI to the department without getting any adequate response. Was an instruction issued to start refusing cases under this rule, and if so, by whom and when? The Telegraph reported on the 2nd of May that Home Office caseworkers had discussed using previous amendments to tax returns to cast doubt on current tax returns. Could she tell me how widespread this practice is? Can she allow people caught up in all of this the right to work, the right to access NHS services and the right to rent during these appeals? Because they often lose these as soon as the administration review is refused, which is the first line of appeal after the initial refusal. And as was mentioned by the Honourable Member for East Renfrewshire, this has a serious impact particularly on women who may be pregnant. Can she tell me, will there be compensation offered to those wrongly caught up in this mess, just like Windrush? People affected can be out tens of thousands of pounds, particularly if they cannot get legal aid for their cases, and because they have not been able to work and have gone into debt and arrears. And lastly, what does the Minister have to say about the impact of this policy on individuals? I've been told by many about the strain on their mental health, on their relationships, both here with their family and with relatives abroad who they are not able to go and visit. The stress of having to report to the Home Office regularly, sometimes on a fortnightly basis, and the loss of employment. And is there a wider economic impact of this policy? Ms McDonough, the Home Office's policy of deliberately targeting these highly skilled migrants is yet another example of this cruel Tory government's hostile environment policy in action. The group being targeted here are highly skilled. They are doctors, they are accountants, they are IT professionals, they are teachers and academics, to name only a few. And they have put down roots and contributed greatly to their communities. The UK Government continue to talk about attracting talent, yet their behaviour towards this group show that they clearly aren't interested in retaining much of the highly skilled population that's already here, who are already well integrated and contributing hugely. I urge the Minister to take swift action now to support the highly skilled migrants who have done us the honour of choosing to live here.